Thank you guys so much for coming to our Paws to Plan, estate planning for you and your pets. We're very excited to have Jason Livingston from Pullano and Farrow here. They deal with a lot of different types of law, but we're going to focus today on estate law. So he's very well versed in pet trusts, and I'm sure he will give you a lot of really great information. All right, with no further ado, Jason.
Thank you, Robin. Good morning, everyone. Thank you for those that are here in person and for those that are joining us virtually. I am, as Robin said, I'm the head of our Trust and Estates Department at Pullano and Farrow, so I deal exclusively in estate planning, estate administration, long-term care planning, and trust planning as well, with some charitable, that can have charitable aspects or can just be there to provide for someone's loved one, including pets. So, you know, what we have here is kind of, what is the idea, I guess, of a pet trust? Why are we talking about that? It is a state, you know, regulated or authorized by statute option for individuals that have loved ones who have pets and are concerned that if something happens to the point where they can't care for them anymore, or if they have to go to somebody else for care, or if they pass away and the pets are still surviving, that they'll be taken care of properly by a caregiver. But then you can also, you know, avoid adding a financial burden on that caregiver by creating a trust structure, which we'll go through in much more detail, but creating a structure where you can fund that trust with assets that can be there to provide for your pets for the remainder of their lifetime, whether it be for daily expenses such as, you know, food, or unexpected expenses such as veterinarian bills or medical needs. And it's there, again, to avoid having to put a burden on the caregiver who's now caring for your pet when you can't. So traditionally, this didn't exist, right? There was no concept of a trust for pets. Trusts were only allowed for individuals or entities, but not pets. And so what would happen is, you know, you would identify a caregiver that was going to take care of your pet when you couldn't, or if you passed away, and you might leave them $5,000, $10,000 in a will, but they really had no obligation to then continue to care for the pet or use that money for the pet's care. And so there wasn't that certainty that they would be provided for, even though it's your intention that they would be provided for financially. So if the pet owner, or if the caregiver chose to just give the pet away, or just use the money for themselves, that was certainly a potential. Then New York State authorized the creation of trusts just for pets with some very, some simple rules, but some rules that have to be followed in there. And we'll go through what some of the requirements are. But you can really create this trust at any time. Oftentimes when I'm working with clients, they create the trust within their will, okay? So when you create it within your will, it's really language that's, embedded in your will, but it more or less is a dormant trust. It doesn't actually get created until after somebody passes away, and then the will is, probated, and then the trust is created and funded. But you don't have to wait to fund it or create it through a will. You can also create it during lifetime. You can create a trust and fund it while you're alive, and we'll talk about some of the benefits or reasons for that in a bit. And then I think Robin wanted to tie some of the other issues relating to the trust into some of these bullet points here.
There's been a lot of changes in the pet trust law, as Jason just said, and the main reason is that the law saw a need, and there's several reasons they saw this need. One is the emotional bond between animals and people. How many of you have pets? And we know about that emotional bond. So now the law is recognizing that that's actually a thing that they want to protect. The other thing is societal burden. 63% of American households own a pet. So thousands of these pets were ending up in shelters like Lollypop Farm because owners didn't make prior arrangements, or the arrangements were not enforceable. So we were ending up with pets or shelters across the United States. Changing social values. We all know that our pets are part of our family. And that thought pattern that they're not just, we just own these things, now they're parts of our family. So that societal change is kind of, the law is catching up with that. And the legal status, now that we have all these pets in America, now we are realizing that there's all these legal issues that have to go with these pets because they are considered part of our family. So hence why pet trusts came about. The pet industry is also one of the fastest growing markets in America. So it's logical to think that we now need some laws around those pets. The other thing too is the alternatives fell short. Pets are living things. We can't stick them in a storage unit until estates go through probate. They have to be cared for immediately. So pet trusts can solve that problem. So the law is finally catching up with what Lollypop has known all along, that bond between animal and human is highly important, and the law and Lollypop can work together to take care of those pets should they outlive you.
All right, so why do we want to have a pet trust? Like we've already kind of mentioned, it's a legally enforceable entity that can be created to hold the funds, and you can really tailor it as much or as little to be as specific or broad as you want. You can talk about, who the caregiver should be. You can talk about how you want the money spent, whether it's in the trust or even in a separate document. You can outline what your, pet's daily routines are and what kind of food they like and what kind of other toys they might enjoy. You can talk about their particular habits as well. And it can give the caregiver, who may not have all of that insight and knowledge, kind of a blueprint of how you want your pets cared for. And again, that money is then there also to help fund and pay for that care. And again, if you want to create it, even that last bullet point, during your lifetime, you don't have to create it within your will. You can create it during your lifetime and fund it at any point as well. And to Robin's point, that can be helpful too, to avoid any gap between the time someone may pass away and the will is probated and the trust is funded. If you have a trust created ahead of time and funded ahead of time, it can be immediately accessed, or the funds in there can be immediately accessed. Now, what do they consider pets? It has to be domestic pets and domestic animals, okay? But that can include things outside of just cats and dogs, right? So if you look at this bullet point here, horses, exotic birds. I mean, horses in particular, very costly animals, right? Very costly to care for, to feed, and to board. So if you have, and we have clients that have horses, if you want someone to be a caregiver, a pet trust is a great way to fund the needs for that animal without having to, again, put a burden on the caregiver themselves. And it can be very broad or specific, right? So you don't always know when you're creating a trust, what pets you'll have when you've ultimately passed on. So it can be broad. It can be as broad as any pets that I have at the time of my death, or at the time that I maybe go into an assisted facility or nursing home and I can no longer, take care of those animals. I have one client that, he and his wife had approximately 4 or 5 cats and a few dogs, so they had a pretty full family. But they weren't sure how that would fluctuate over time, so they designated a certain dollar amount. I think it was $5,000 for any pet that they have at the time of their death. And so if they have 3 or 4, then $15,000 or $20,000 would go into this trust to care for those animals for the remainder of their lifetime, which is a little bit different because it might even be on one of these slides. Prior to a law change, these trusts could only last for 21 years, okay? And that goes back to a whole perpetuities reason that I learned in law school a long time ago, and I can't really remember or explain without a whole semester of time, but it would only last for 21 years. Now for traditional cats and dogs, that might be, certainly enough time, but when you get into other animals like exotic birds, my stepfather has an exotic bird, and I'm worried that one day I will be taking care of that bird, because I understand that they can last for several years. So, but now who manages this money? So I've talked a lot about the caregiver, okay? The caregiver is the person caring for the pet. That caregiver does not necessarily have to be the one in charge of the money, but they also can be, okay? So there's a different person involved, and the title for that is a trustee. A trustee is an individual that manages and makes sure the money is being spent properly within the construction of the trust itself, so that the money is used, again, for the intended purpose. That trustee can oftentimes be the very same person as the caregiver, but it doesn't have to be. But you definitely do need to have a trustee, and you outline that, and you get to choose that person or persons when you set up the trust, whether it's in your will or in a lifetime trust document itself. The trustee, again, is there to make sure that the money is spent properly, to enforce that, and they're the intended person to, carry out your wishes and make sure the money is spent properly. And then we would always have successors as well. So you start thinking of the people that you would not only trust to care for your pets, but also to manage the money and make sure it's spent properly. And then how is it funded? Okay, so we've talked a little bit about this already, is it can be funded in different fashions. It can be funded while you're alive if you want to create a lifetime trust and fund it with a dollar amount. Now, even if you fund it while you're alive, it won't actually be spent or used or triggered until either, that individual passes away, or you go into, a different living situation where you can't care for the pet any longer. Or if it's through a will, then the trust would be created as part of the, traditional probate process of the will, and the estate assets that are available would fund that trust with the preset dollar amount, whether you set a hard dollar amount or base it off of how many pets you may have at the time of passing. I say here there is a reasonableness standard, okay? So there is a limitation on how much property can go into this trust, and we'll do a little slide next on, if you remember Leona Helmsley, she had a very interesting outline in her pet trust that was ultimately changed by the courts. So I say, maybe $20,000 is a reasonable amount. Again, that can be adjusted for how many pets you may or may not have, or what types of pets. Again, horses are going to require maybe arguably much more funding to last for their care for their lifetime. So, Leona Helmsley, back in now 2007, when she passed away, she put $12 million into a trust just for her one dog, appropriately named Trouble. And so I think her remainder beneficiaries felt that this was a little excessive, okay, because they were like, that's way too much money to be put in there. It's delaying our potential inheritance. And so, as you can imagine, it went to court, and the judge ultimately still knocked it down, but still left $2 million in that trust. So still a very high dollar amount, but maybe it was the judge's way of trying to strike some balance. Again, I think there were arguments made on the side of Trouble that their care was $100,000 a year. Seems a little excessive, but yeah, absolutely.
Just say you put $50,000 in a trust for 2 pets, 2 dogs. Now, what happens once those dogs pass away if the trustee doesn't, or the caregiver doesn't spend all the money?
Yeah, absolutely. So you don't have to be worried about overfunding it because really the trust dictates what happens to the remaining balance of the trust assets once all of the pets have eventually passed away. So you outline your wishes at the very beginning when you set up the trust. So it can go to your other remaining beneficiaries if those are family or children or friends, or it can also go to charitable interests as well. So it's a very good, funding mechanism to help care for your pets after you've passed. But then if you have charitable intentions, such as with Lollypop, the money that's remaining or left over ultimately can also go to benefit that purpose as well. Yeah, you see here, I think ultimately it went to, with $2 million for one dog, it did not all get spent and ultimately was directed upon the passing of Trouble to go to her charitable foundation. So. And then the money can be used, again, for the care of the pet. So the principal, if you have money in there, like $50,000 as an example, that would also be invested properly. The trustee would be responsible for making sure that it's, a money manager or somebody is making sure that it's invested and it can earn interest, it can earn, and it can even grow. And then either the income or the principal as needed for the care of the pet can be used for that purpose. And it can only be used solely for the pet, right? The trustee cannot just say, well, I'm spending time, or the caregiver can't say, I'm spending my time and energy, so I want to get, a salary or an allowance from the trust for myself. That's not really allowed, okay? It can be there for just actual reasonable expenses. Now, saying that, the trustee, as with any trust in New York State and other states, can be entitled to a commission, all right? So that is a percentage of the balance of the trust each year. It's an annual commission. It's usually 1.05%, so annually. But that can also be modified or eliminated, right? That's just the New York State statutory default amount. You, when setting up your will or setting up the trust, can dictate, the trustee gets half of a commission or gets no commission if you're naming a family member or a close friend that you don't think would want or desire a commission. Yeah.
Who keeps an eye on the trustee?
Good question. Yep.
Repeat the question for the people on.
Yes. Okay, so the question was, who keeps an eye on the trustee? Who's watching the trustee to make sure this is being spent properly? And there's a couple different layers. One is if you have a different trustee than the caregiver, then the caregiver would be part of that and which should be seen that the money is spent appropriately. But if you don't even have that, there's remainder beneficiaries, right? So if it's your children or your family or friends or a charity are the remainder beneficiaries, there's ultimately going to become a time when that trust is settled that they will be able to question and make sure that the money was spent properly. Even outside of that, the court itself can also oversee. So when you have a probate proceeding with our local, let's say, Monroe County Surrogates Court or Ontario County Court, the court is ultimately involved when you go to terminate the trust. You have to present an accounting to make sure that the money was spent wisely or spent appropriately, because there are remainder beneficiaries involved in addition to just the pets themselves. Oh, here we go. Yeah. So the length of the trust used to be limited to 21 years, again, for that obscure perpetuities rule. Now it can exceed that, so it can last for the entire lifetime of the class of pets that were alive when the trust was essentially funded or created, right? So if you pass away and you have 3 or 4 animals, it's those 3 or 4 animals that would be the measuring lives of that trust. And it wouldn't, so it can't extend longer than once the last pet passes away. And again, any remaining trust property left over once the trust terminates does ultimately go to whichever beneficiaries you choose when you set up the trust. Family, charities, friends. It's really your decision, and you can direct it in any way you want. And it's my job as a trust and estates attorney to make sure that your wishes are drafted into the language so that it ultimately accomplishes what your goals are. And again, good questions. The court here retains the authority to make sure that the intent of the trust and the intent of the creator is carried out. So that, let's say you have a trustee that is also the caregiver or the remainder beneficiary, or maybe they're the trustee and the remaining beneficiary or not the caregiver. Well, one, they could maybe use the money inappropriately, or 2, refuse to pay money out, because any money that they pay out as trustee for the care of the animal reduces ultimately their eventual inheritance. The court can step in and compel them to use the money appropriately, or even remove them if it's just not going, if that trustee just is not the appropriate person, and replace them with somebody else who will manage it according to your wishes. So here are some suggestions. Name a trustee that you are familiar with, that you trust and believe in. I always want to have a successor trustee. I always want an alternate agent fiduciary to any position, but in this case, it's for the trustee. You can identify your pets, such as photos, microchips, or just describing them as a class. Again, we say any pets that I own at the time of my death, or if I fell ill and could no longer live at home. I always encourage clients to, write kind of a letter of instruction to their caregiver and trustee, even if it's the same person, outlining what kind of standard of care the pet receives, what types of food or activities do you provide for them and want to see to continue to be provided for them. And then you're just making sure that you're giving enough funds into the trust to anticipate the needs and the care so that there's adequate money. But again, if you overguess, I always say it's better to overfund it if you have the means to, because anything that is left over will ultimately go back to your beneficiaries of choice. And again, more suggestions. You can even put in what your wishes are for when the pet passes. Do you want them, how do you want their remains provided for as well? Where would you want them to be buried or cremated? And again, that caregiver, that trustee is there to make sure your wishes are carried out, which is really the entire intent of the trust itself. It puts in some security that when you choose those people to care for your pets or handle the financial funds to provide for that pet, that it gets carried out according to your wishes. And then again, designate a remainder beneficiary so that you're ensured that any funds left over will go ultimately where you want them to. And then I think Robin can tie in the pet guardian program and how these two can sometimes dovetail together.
Yes, so the pet guardian program, how many people are familiar with that? Have you heard of that at all? Anything? Okay, good. I can tell you all about it. The pet guardian program is created as a thank you to our Legacy Society members. We will take your pet, should they outlive you, as a thank you and for leaving a gift in your estate. You fill out a huge questionnaire all about your pet. You can tell us everything we need to know: where they sleep, how they sleep, what favorite toys they have, what kind of treats they like, anything. And then attach a picture to it. And then we will take care of your pet and love them as our own, and then try to find a new home for them. We like to kind of refer to it as the concierge service, as a thank you for your gift. Now, what is the Legacy Society? The Legacy Society is a group of people who felt compelled to leave gifts in their estate to Lollypop. It's important because it helps fund our future, and it funds the future of animals as we go forward. So that's my job. This is what I do. I help people kind of figure out how they want to go forward with that. So there's lots of ways to do it. The easiest way is to leave a gift in your will. It can be a percentage, it can be an amount, a specific amount, whatever you want to do. You can also do beneficiary designations, so you can leave Lollypop as the recipient of your IRA account or bank account or life insurance policy. Those two are really easy ways to help the animals. We can also do some gifts that actually pay you an income. So if you wanted to prepare for retirement and you were kind of concerned that maybe you might need some extra income, you can fund a charitable gift annuity or a charitable remainder trust, and they actually pay you an income while you are still here with us, and then the remainder is left to Lollypop at the end of it.
Yeah, so like Robin said, there's several ways to accomplish a charitable gift, and I help counsel clients in that, routinely, whether it's preparing proper language within the will. There's also very compelling tax reasons to leave a beneficiary designation such as an IRA to a charitable, to accomplish your charitable wishes, because it saves and avoids the tax. So there's a lot of easy and relatively convenient ways to go about it.
Jason, there's a question on the Zoom.
Oh, good.
I have a pig. What if the person who is supposed to take care of her can no longer care for her for some reason? What happens to her and the trust?
Yeah, so the question is what if the caregiver can't manage or take care of the pet prior to the pet passing away. Again, I'm always asking clients to name multiple agents, alternate agents to any position, and I think the same would be true for the caregiver. And then ultimately, I don't know if there was no caregivers, then I think a Lollypop Farm would be, you know, an option to care for the
Pet
pet.
guardian program would
Yes.
be a nice backup.
Yep.
Yes, exactly. Yeah, so you could combine that pet guardian program. You'd still have the trust available assets. The money is there to help care for the animal, the pet, but again, ultimately, it can go to the beneficiary, remain a beneficiary of choice, so, which can also be
Yes.
Lollypop Farm, yes.
Of course.
Yes.
All right, and so if you have any more, you know, questions about Lollypop Farm, obviously you can connect with Robin. There's her information. If you have any questions for me, oh, we have a question.
Do you have a couple questions?
Sure.
So how easy is it to update a trust? Because as you proceed, you decide the caregiver you decided on, you needed to change it, or you wanted to add pets. Should you start broader and go to more specifics if you can't update it, or?
Yeah, so the question is once you set up a pet trust, how easy is it to update it, modify it, or change it? And it's really not that hard. If it's embedded within the will, the trust isn't actually created until after somebody passes away. So at any point in time, you can update your will, whether that's through a codicil, which is an amendment. It's just another word for an amendment. You can amend the will to update that pet trust provisions. If you create what we would call an inter vivos, which means a lifetime trust, and so it's not within your will, you're creating the trust now, can easily be, it's revocable, so you can change it as you wish. So you can update that the same way you would update through a will, which is just through an amendment.
Which would also include the amount of money that you put in it, as well as different specifics.
Yeah, so yes, absolutely. And what you can do is direct how much, so let's say you choose $10,000 or $20,000 but want to change that, up that or reduce it, that is part of the amendment process. Or it can be part of the funding process. So if you have a life insurance policy that has a beneficiary designation, if you have you can have 10%, let's say, if it's a $100,000 policy and you want $10,000 to go to the trust, you can have 10% go to the trust, either that's embedded within your will, or if it's a lifetime trust, you can just name the trust. And then if you want to update and change how much goes into it, let's say now you want $20,000, you don't even have to amend the will or the trust. You just change your beneficiary designation from 10% to 20%. So that's another option too.
One more question.
Yeah, absolutely.
Income tax? Okay, trusts, do you have to pay income tax on trusts? I don't know much about trusts.
Sure, certainly. So a trust, the question is what are the tax consequences of funding or using the trust? And so a trust, let's talk about a little bit what a trust is first. It's really just a legal entity that gets created, but it's all on paper. Really, it's a 5 or 10 page, let's say, document that names, who is the grantor, which means who created it, who is the trustee, who is the caregiver, and whatever other specifics you want to put in there. And once you sign it and it's created, it is a legally controlling document. And then that entity can own things like assets. So you can go, the mechanics of it would be you go to a bank account, open up a bank account in the name of the trust, and then put whatever money you want in there. If you do it while you're alive, if you do it upon death, that would be just funded as part of the estate process. Now, if that money is in there and earning income, oftentimes that income is what's being used to care for the pet, and if that income comes out, then the taxes you're still taxed at the trust level, but it's better to have income. I guess you don't have to invest it. You could put it in a non-interest bearing account too if you're worried about the tax consequences, but it would just be another legal entity that would, if it earns enough income, and if the dollar amounts are smaller, if you have $10,000 in there and it earns $100, you don't have to file an income tax return for that. If you're talking about bigger dollar amounts, then you would just be, I guess it would just be part of the trustee's it would be the trustee's responsibility to make sure that the income tax returns are done properly. Yeah.
Say you're married and you do the will as a couple, and just say, if I pass away and my husband isn't able, or I pass away and then soon he passes away, like, a year later, do you have to put that in your will? I mean, the pets would go to the husband, but when would he have to do a separate will on that, or a separate?
Sure. So the question is if you have a married couple, how do you incorporate a pet trust within one or the other's will? And the answer is really you put them in both. So the way that when we work, obviously, with a lot of married couples, we almost always, obviously there's exceptions, but typically a spouse's wills are mirror images of each other, okay? So that way the order of passing doesn't dictate who inherits or change who inherits. So if a married couple leaves everything back and forth to each other upon the first death, then when the second one dies, the pet trust that's in their will is what gets created. So in your example, if you passed away first, you would have a pet trust in your will, but it might not get created because everything first goes to the surviving spouse, and then when the surviving spouse dies, that's when the pet trust gets created. You don't have to have it that way. You can create it upon the death of the first spouse if you want to. It's really, when you're creating a will, you can craft it almost any way you want to, and we help counsel clients on what their options are, and then ultimately draft the provisions so that it matches their wishes. What?
So say you have a spouse that would not want the animals. You could put that in your will that the pet trust gets created even though your spouse is still alive and
Yes.
Farrow?
Yeah, absolutely. So the question is let's say with a married couple, the spouse is not going to be the caregiver, and ultimately one of the spouses is really not interested in being the caregiver or creating a trust if they pass away. The other spouse can certainly, yes, you can have it within your will that if I pass away first or second, this trust gets created for the pets and gets funded with X dollar amount or X percentage.
The question on Zoom is, how long does the pet trust take effect after the death of the donor? How long is it in place?
Okay, yeah, so the question was, how long does the trust last once the donor passes away? And the answer is it lasts for the lifetime of the pets that are alive at the time that the trust essentially is, created and funded. So if that is, 5 years or 40 years, depending on the type of animal, that trust would be in existence, or if it ran out of money, then it would ultimately, be collapsed at that time too. Yeah.
So if you did the legacy program, say, like immediately you have to contact, it would be in there that you have to contact you to take the animal.
You can put it right in your will.
Right.
Oh, sorry. So she asked if you are part of the Legacy Society, how do we know as Lollypop Farm that we're going to take your animal? And that is drawn out in your will. We do have some sample wording that you can put in there, and then instructions for whoever is your executor that the animal can go to Lollypop. We keep on file any information on your pets. So once they come through our doors, we can look in their file and know what to do with them. Does that answer the question? You see, okay, are you sure? Okay.
Yeah, I mean, the Legacy Society too, independent even of the pet guardian program, is such a great, concept that I know came up when it was created when Kathy joined the organization, because we met early on when she started here, and I've been a sponsor of the Legacy Society annual gathering for the last, 10, 12, 15 years or something like that. So it's a great way to, the way I've always described it to my clients, is it's a way to thank an individual for their legacy gift while they're still alive, and you can thank them. Because so often you might not know somebody's a donor until after they've passed away, and now, a charitable gift is given to Lollypop through their estate. after their passing, but you can't thank them. You can thank the family, but you can't
Can't
thank
thank
them.
them, yeah.
So the society is a way to thank them in advance, so to speak. So when I meet with clients, if they want to leave a charitable, or when they leave a charitable gift to Lollypop, I ask them, it's obviously confidential. I can't call and say that unless you give permission, but I say, oh, if you want to be recognized through the Legacy Society, I'd be happy to, you know, pass your information on to Lollypop that you've made a planned gift to the organization. If not, that's your wish too. But.
Thank you so much for coming, guys. We really, really appreciate it. It's so good to see people in person. Yay!